go through our specific techniques and solutions for these type of matters. There are a number of them we're going to talk about here. First and foremost would be to the extent that the author or poster has posted something online about your business, of course, one thing to do would be to convince him or her to stop and remove it. Of course, if you can do that, there's kind of two ways I usually go about it, right? We call it the carrot or the stick approach. We'll talk a little bit about that coming up. But secondly is a cease and desist letter, which is more probably the stick approach, right? Sending a letter and demanding removal before you proceed with your viable legal claims, assuming that they exist. Another option, of course, is to contact the website and actually request removal. We'll talk a little bit later about going after the website and why you cannot do that in 99% of cases. But certainly nothing is stopping you from reaching out and seeing if you can't work out a solution. Along those lines is looking at the terms of service of the website and potentially using that to craft some sort of request. We'll also talk about obtaining a court order and filing a lawsuit about content online. Again, certainly we do that, and I have a lot of experience with that, but it's not the solution every single time for various reasons. Also talk a little bit at the end about the Digital Millennium Copyright Act and trademark considerations and unauthorized sales, which we do a decent amount here at Voorhees now, and depending on how much time we have, we can talk more or less about that if people are interested at the end. This next slide just talks about when removal is usually the best solution, of course. When I get people to call and they have content online and obviously they just want it down. They don't want it out there anymore and want it to come down from the Internet and want to know how to do that. And the reason for this kind of goes, this next slide talks about it, search engine optimization and what works and what doesn't work. I have a lot of people call and say, oh, well, I hired this company and they were doing SEO and it worked for, a day and then it didn't, and someone's going to talk to someone at Google, and I've yet to see anyone who has figured out Google's algorithms. As I tell people, Google is employing a lot of very smart people to create their software, which is then, creating the search results that we all see and use on a daily basis. So, for me, that's definitely something that a client can and should in certain situations, think about, and obviously thinking about one's online presence is important in general, but it's definitely not a catch-all and is, as we've seen, is becoming more and more difficult every month. It becomes a bigger issue in terms of, oh, well, I pushed it down for this long, but now it's coming back up. This screenshot here kind of shows the different how search engine optimization is changing, and how even Reputation.com, which was one of the big companies that purports to do this, even their online reputation is not all that great. And you would think if they can actually do it, they would have done it for themselves, of course. So that's just something to keep in mind in terms of thinking about solutions and whether to move forward with attempting removal or looking into just, quote, pushing it down, is kind of what we call it colloquially, right? Next is we'll talk a little bit about convincing the author to remove his or her post or to stop the attack. This is a good solution in a number of cases and usually where we start. Obviously on many websites or forums, the author can go back. If I post something on a website and then later on I decide I want to remove it, most websites and various forums and social media and blogs and that kind of thing, unable to do that. So, of course, that's an easy answer in terms of, from a cost efficiency, timing standpoint, is to, reach out to the author and see if you can't convince him or her to log back onto his or her account and remove it. We see this obviously with social media all the time. People still have access to all their content. They can get on, they can delete, they can remove, they can edit, take out certain things. Other websites like Yelp is another one that you're able to go back as a user to your former Yelp reviews and either delete it or remove it, and that kind of thing. Glassdoor is also another website that we can talk about a little bit later that I'm getting a lot of calls about. For those of you who don't know, it's basically employment website forum for employers and employees. Employees can get on and rank their companies and talk about their employment, whether they liked working here or didn't like working here, and that kind of thing. This, as you can imagine, brings up a lot of issues because it raises all kinds of concerns with employment law and restricting employee speech. So it's a little bit of a completely different analysis than most of the websites we deal with. But that's another website that someone still has access to his or her content. And so to the extent that you can work with the author and get them to remove it, that from my point of view is the most efficient and way to go about it. So as I mentioned earlier, obviously there are various ways to convince, should we say, the author or the poster to remove. First is what I call the carrot approach. This is obviously, reaching out and seeing if you can't resolve the issue. If you have a bad Yelp review and someone's unhappy with his or her meal and, says, oh, the chicken was cold and I didn't like the coffee and all of that, well, of course, on my end, the easiest thing to do is to reach out and see if you can't convince that person that, to try your restaurant again and come back and give them something for their trouble and see if you can change their mind, right? We're operating in a world that people, of course, are allowed to post their own reviews, and to the extent that the review is coming from a place of dissatisfaction, the easiest way to fix that is to actually satisfy the person. Ask the customer what would make him or her happy at that point. I also tell people as we go through these type of, when I get companies that have online issues and all of this content, and, one of the first things that a company can do from the beginning before they even see these issues is having very well-trained customer service people or representatives to stop it before it starts. Don't be the company that waits until you have a ton of negative content online to start reaching out and trying to fix your issues. Be on the forefront of it so that, you don't even have the issue and you don't have to come and start asking about how to clean up online reputation issues. Obviously, on that same vein, to the extent that it's a legit customer and there's no viable, really legal claim, it's opinion and it's this person had a bad experience, a couple of thoughts to keep in mind when going through that is, to monitor your online results so that you can reach out to the person shortly after the incident happened or after the post was made. Be on the forefront of it. Also posting a response and including a phone number or contact information, in my view, does two things. One, it really gives potentially the poster the ability to reach out and see if you can't work out the issue. Of course, if they just ignore it, the other thing that I think that does from a company and brand online reputation standpoint is, it shows a reader further down the line that your company did care about this posting and damaging content and actually did something about it and wanted to try to make it right. So that's something to keep in mind as well. Should you be able to actually work something out, and come to an agreement, if someone was unhappy with your service and you work out an agreement and some sort of payment to refund some of their money, obviously I would recommend on that end, to the extent that the damaging content that they posted online got your company's attention and wanted to repay him or her and make it right, so to speak, always would recommend coming up with some sort of settlement agreement. Obviously, we don't like to recommend, including just a broad non-disparagement or confidentiality agreement in any kind of contract, but to the extent that you're negotiating a settlement and someone is going to remove online content and you're paying that person for that, at that point, you can actually ask them to somewhat restrict their future speech. And we can talk about that a little bit later, too, in terms of the constitutionality of that. But that's something to keep in mind that when working out settlement agreements in these type of matters. Next, we'll talk about a little bit more about what I would call more the stick approach, sending a cease and desist letter. Before we get into kind of the nuts and bolts of that, I think on the same vein as the Union Street Guest House, it's important to keep in mind this, what I call a case study of the Ron Gordon watch repair shop. Ron Gordon had obviously repairs watches. He had a customer come in, got his watch repaired or not repaired. He was unhappy. He posted a review about it on Yelp. Ron Gordon wasn't happy with the review on Yelp and had his attorney, Mr. Spinell, send this letter here that basically in just a few sentences just demands that he remove the Yelp review. Problem with this is that Mr. Spinell didn't have a ton of facts or law to back up his claims that it was actually a defamatory posting and not just his, own opinion, negative or otherwise. And the media picked this up and the story went crazy. We call this the Streisand effect, which of course refers to Barbara Streisand getting very mad about her house, photos of her house on the coast being posted on some place online, and she got mad and she sued, and of course the next thing that happened is that all the major news articles picked this up, and the few people that had seen the photos, of course, now exacerbated and into the millions, and it's like, if you were really that mad about the invasion of privacy, you probably shouldn't have filed a lawsuit about it. That's exactly what happened here, and now, if you looked today on Ron Gordon's search results, he actually has some pretty good reviews, but there are actually also a website from Gawker as the third result about, basically addressing the fact that this letter went out, and CBS News also picked it up. And so it's just really important to keep in mind before you fire off letters demanding someone remove content that you really have a good faith basis for it. Obviously, ethically, that's always important, but even more so in the world of online content that, the first thing that someone can do when they get your letter, we're living in a different world, right? Even if they want to just throw it away and ignore it, as they may have done 10 years ago, they certainly can snap a photo and upload it to their social media, and the next thing you know, you've gotten yourself into a PR nightmare. So when drafting a cease and desist letter like this, again, obviously ensure that you have legal grounds for threats. That's important all the time, but it's especially important here that you don't end up in a situation that you look like you didn't do your due diligence and really have a good faith basis for this. Another thing, even if you do have a good faith basis, something that I always talk through clients before, addressing potential legal claims is to make sure that, how do they want to be perceived if this letter came out and was posted all over online and on, nightly news tonight. What's the tone of the letter going to be? Are we going to look like the bully here, or the victim that something untrue and unfair about our company was posted online? And so that's always important in terms of drafting the letter, is, taking it with an eye that if it went, quote, viral tomorrow, how would we look? And do we look like we have, done something a little untoward, or are we in the right here? Another thing to keep in mind if you are going forward with this, if, you have a posting online about your company that is just completely factually false and very damaging and harmful, and you send a cease and desist letter, another strategy is to not only send a letter but also include the complaint that you are prepared to file if the poster does not remove the content. My experience, that gives it a little bit more teeth, and people can see that and see that you're really serious and have put the time and resources into being prepared to go forward with your legal claim and litigation. Next, we will talk about contacting websites. Obviously, if content is posted on a website, the website administrator has access to delete or remove that content. Certainly, contacting a website is not a bad idea. In many instances, I like to put a caveat here that this is a good time to mention the Communications Decency Act. It's a federal statute that prohibits liability for a website for the content that a user has posted. In short, and to be very short and simple about it, that means that if I post something on Facebook that is defamatory, you can't sue Facebook for my content. You have to sue me. I'm the speaker of the content, I'm the publisher of the content, and I'm the one that's liable for it. Facebook, as the website that it's being, published on or hosted by, is completely immune from liability with very few exceptions. That said, that doesn't mean that you can't go to the website and ask in certain situations if the website would consider removal of certain content. Here, this slide talks a little bit about certain things that in my view are types of content that's always good to keep in mind. Maybe a request to the website is worth your time. Again, back to the balancing of factors, this is the small outlay of resources, right? To go and say, hey, there's this content, would you think about removing it? That doesn't take a lot of time or money, and, depending on where you want to be, if they remove it, you're in a good spot. So to kind of go through this just quickly, obviously IP, intellectual property, copyright, and trademark infringement, oftentimes websites are willing to remove. Threats of violence, child pornography, obscenity. Impersonation, that's an interesting one. I've had a number of instances that on social media, the company or person is having someone go on an attacker and create a fraudulent, profile and purporting to be the CEO of a company. We've had that on some review sites as well, forums that people go on and use screen names and pretend to be, someone high up in the company. So that's a unique situation, but something that is something to think about, that if someone is impersonating you or your client on a website, that's another thing that you can go to the website and ask about. Court-ordered removal, we'll talk about that a little bit more, and confidential information, if your bank account or Social Security number is posted on there, that's something to definitely potentially go to the website and request removal. In terms of approaching the website, every website's a little bit different, and that's when I talk to clients and potential clients, that's what I always tell them. Where the content is posted is one of the biggest factors in terms of what you should do here. Obviously, the Communication Decency Act shields all of these websites from liability, but the sites and the hosts always have terms of service, So every website's a little bit different in terms of their own policies and what they will entertain in terms of removal or looking at it or entertaining these type of requests. My suggestion on this is, at any time when you're reaching out to these websites for these type of requests, of course, as I always, keep in mind, you catch more flies with honey than vinegar, so to speak. So, being deferential and recognizing that they don't actually have to do anything legally, but that you're would be appreciative of them taking a look at this content and with an eye to their own terms of service or their own policies. You'd really appreciate it and see if you can't open a dialogue. Every site's a little bit different with that, but, in my view, I get a lot of people that call and they say, oh, well, my lawyer, my business lawyer, sent a demand to Facebook that they remove it, and we got no response. And to me, well, that's not surprising. The second you start threatening these type of websites with lawsuits that is never going to work, they won't even talk to you. Now, of course, there are plenty of websites that won't talk to you regardless, but threatening them first is a good way to get that, to ensure that they're not going to talk to you. Just a quick recap, I mentioned first, in terms of contacting the websites, obviously the CDA, here's the statute here, 47-230. It shields interactive websites from being held liable for third-party generated content. The CDA is important in two ways. Number one, first and foremost, of course, you can't sue the website for the content. The second way that it's important is that at the same time, just because if you got a court-ordered or a court order relating to content posted by the actual poster, in the same way that the CDA, provides immunity for liability, it also doesn't require the website to actually do anything, right? Because the order is not against the website, it's not obligated to do anything with it. And we'll talk in a little bit about certain websites and what they will or will not do. But, to be clear, when addressing these issues and talking to a client, you need to know what your expectations are before you spend a bunch of time and money on litigation and going after even the poster and getting a court order declaring content to be defamatory or otherwise unlawful, and then thinking that you can turn around and go to any website and that they're then required to remove it. That just is not the case. So that's important to remember in terms of before you spend time and effort getting your actual court order. There are a few exceptions to the CDA, and we can talk about this more if anyone has specific questions, but, lots of courts have interpreted it. Obviously, every situation is very fact-specific, but to the extent that the website actually did contribute in whole or part to the creation or development of the content, potentially they have waived their immunity of liability. I don't see that happen very often, right? Just posting it, even moderating content. People ask me that all the time. Oh, well, they get to decide what goes up and what goes down. Still doesn't matter. They're allowed to have what's basically an editorial function, right? Because of all those things we talked about earlier, that, obscenity or other content that may violate a website's policies. A lot of websites don't allow you to post full names, for instance, on Yelp. They don't want you to post. You can post about, Jimmy's Bakery and how you had bad service there, but you can't post that Betty White was serving you and she's a horrible server. They don't like people calling out specific people's names. They want it about the actual business. So they are allowed to maintain that editorial function, and it does not get rid of their immunity from liability. IP claims, this is obviously also a little different. Every situation is a little different, but in general, trademark and getting into other IP concerns, the CDA doesn't apply the same way that it would to publications of speech, whereas we see it most often. I alluded to this just recently, just before, about looking at a website's terms of service and other policies. Here's my example of at Yelp is in the content guidelines. They don't want you to publish people's full names and that kind of thing. So to the extent that the post that you're concerned with has that, that's a good basis to approach the website and see if you can't ask them to review it under their own policies and potentially remove it on that basis. This next slide is about Wikipedia and approaching the website. I won't get too much into this unless anyone has a specific concern, but I do like to talk about it because I get a number of questions about it on a regular basis. And Wikipedia is a unique website in terms of the content that's posted there, right? Because it's not its own content. It's always one of their biggest things is for something to be on Wikipedia, it has to be fair, neutral, and well-sourced, meaning that there's actually a source and that people aren't putting their own content on there. They have to go out and get it from somewhere else. So that's always where I start with that kind of thing, is that if you have a problem on Wikipedia, you probably have a problem somewhere else too, because if it's not well-sourced, it's going to be taken down usually pretty quickly, to the extent that it isn't well sourced and it's up there, or that the source is not a good reliable source. I always recommend that people work with editors. There's a whole procedure to go through, but a big takeaway from this is to not try to edit one's own Wikipedia page. It's arguably against their terms of service. And I've seen people get into big quagmires by trying to get on there and edit and delete things, and then all the Wikipedia editors come in and start changing things, and it's just easier to kind of walk through the process and ask someone to help you. A couple other websites that are of note in terms of when we're talking about approaching the website: Twitter, Facebook, and TripAdvisor. These are all from their website in terms of the terms of service. So these are important things to remember when you're approaching the website, to use this policy and come back and say, recognize that your policy says X, Y, and Z. This is why this content we think may be in violation, and we would appreciate your review of the content given this. Just to recap here, tips for contacting the websites. Don't do it unless you have a good reason. I always say, it's a little bit of the boy who cried wolf, right? If you're constantly contacting a website and saying, take this down, take that down, they're just going to start ignoring you. So, use your collateral when you can and when it's worth it. Find the right person. Usually websites have people who monitor content or the community guidelines, that kind of thing. Those are the people to address your request to. Obviously it can, of course, go to a lawyer or someone, maybe in a little bit of a different situation, but I find particularly when you're just requesting these type of review, and that's all it is a request, it helps to go more to the person who actually can do something about it and, not to someone in some completely different division of the company. And then, of course, just make your case. Explain who you are and why you're contacting them. Again, in my experience, being deferential goes a long way, and realizing that they don't have to do anything, but you would appreciate their help, and then explain why you want the content to be removed. If deletion's not possible, if they won't take it down, there are alternative solutions, and we can talk about that in a little bit. I'll talk about that when we talk about newspapers. I get a lot of questions about that, so that's usually, in my experience, where that comes in. As a kind of just practice tip, something that's good to keep in mind, to the extent that you do get content deleted from a website or someone changes it or edits it, you may see, it came down from this website, but it's still on the first page of Google, so why isn't it coming down? Of course, the answer is, well, that's not how Google works. When you put a search term into Google, Google is not, going out in real time and searching the entire Internet. It's searching its database. So they constantly have crawlers that go out and look for websites and content, right? So to the extent that a website gets changed or deleted, it may take days or weeks or even a couple months for Google to update that in its cache, to recognize that that's no longer there. The way around that is to actually go to Google, and there is a tool that it's easy to find, that you can go and just request that it basically update its content to recognize that that's no longer there. So this is a good tool to use to the extent that something gets changed or deleted. You can get the search results updated in usually 24 hours with this tool, as opposed to just waiting for Google to figure it out on its own. Next thing we're going to talk about is probably something that I get the most calls on, is basically getting a court order relating to the content. As I mentioned in the beginning, this isn't something that we recommend doing all the time, because you basically, to get your court order, you have to sue the poster. But assuming that you do have viable claims against him or her for defamation or otherwise, you can, of course, sue that person, and assuming that you can get to the point where you can get a court order declaring the content to be unlawful, that oftentimes is very helpful in terms of getting the content removed. Most websites, in my experience, will basically honor a court order against the person who posted it, right? If John Smith posted something about your company that was completely factually false and damaging, and you sued him or her for it and got a court order, a judgment against him for posting defamatory content about your company, in my experience, most websites that you go to will look at that court order and say, okay, you didn't sue me, I'm immune, obviously, from liability, but you sued the poster, and a judge has found in a court of law that the content is unlawful and defamatory, so I'm going to remove it. Not only is that, at the risk of speaking for the websites a little bit, in my experience, most of these places figure, well, okay, I don't want to be the arbitrator of that. I'm not the one to decide whether something's defamatory or not, but if you actually went to a court and got a judge to decide that, or a jury, or otherwise, then fine, that's good enough for me, and that seems fair, I'll remove it now. Of course, the other argument is similar, is that, well, you don't want unlawful stuff on your website if it's been declared false by a judge or otherwise. Why would you want to keep it up there anyway? So, this is definitely an approach, assuming that you have viable claims. You can also get, short of going all the way through litigation, of course, if you decide to settle with the poster, you can get an agreed order that the person basically signs off on the fact that he or she posted online unlawful content, and that will work in most places to get the content removed. All this said, as I mentioned in the beginning, it's important to remember that the order, again, is against the poster, not against the website, and you're looking at potentially taking it to the websites and just simply requesting. You don't have to. They don't have to honor it. It's not an order against the actual website. It's not an order against Yelp or PIS Consumer or even Google. So there's no guarantee, so to speak, that the websites or the search engines or anyone else is going to do anything. All you can do, again, is a request. And to go back to contacting the website section, that's important to keep in mind in terms of when you're reaching out, even with your court order. I wouldn't recommend saying, hey, I have this order, take it off, or I'm going to sue you. That still doesn't work. What you need to do is reach out and say, I have this court order. It's declaring this content to be unlawful, defamatory, in violation of, contract, breach of contract, or what have you. And would you please review it pursuant to your terms of service? Again, as we mentioned before, most websites have terms of service that prohibit unlawful or defamatory content. On that same line, or same vein, obviously every website has a policy that's different, and even a policy that is simply that. I mean, it's not a legal statute that says that they have to do anything. These are 4 websites that we're going to talk about a little bit, and what we do, just because these are 4 of the ones that we get the most questions with. You bear with me just a second. I switched up these slides a little bit. So, Ripoff Report is a website I mentioned earlier. It's a consumer protection website. People can go on there and post about their experiences and, companies and goods and services and that type of thing, and create a Ripoff Report. This is what the website looks like. This is just a slide of kind of the front page at one time, so you can kind of see the setup here. But as we showed earlier, Ripoff Report ranks pretty highly on Google. So it's something that a lot of businesses call about because obviously the fact that it's on there is a concern, but the fact that it ranks, either right below or right above their company page oftentimes is a very big concern as well. Ripoff Report's policy is that the poster can actually not remove his or her content. Once you've gone on there and posted, it's a permanent record on the website. So, even if you have someone who posted about you on Ripoff Report, if they then regret it and say, oh, okay, I'm really sorry, I'll take it down, they go back, that's just not going to happen. So, that's something to keep in mind when you're dealing with that. We'll talk in a little bit after I talk about these next websites what you can do in terms of potentially getting some of the content updated or removed or actually off the search engine. The other website that we get a number of calls about is pisconsumer.com. Again, here's a screenshot of what it looks like and kind of on the front page. I would say in the past year or so, we've seen PIS Consumer's domain authority increase a fair amount. I'm getting more calls about it, and it seems to come up higher on Google Search Index, and I have to think that the more calls I get about it, that's a reason for it. People aren't overly concerned with what's out there unless they're seeing it on their Google search results or other search results. PIS Consumer is similar to Ripoff Report in that a user cannot go back on and delete his or her content. Once it's posted, it's posted. The difference with PIS Consumer versus Ripoff Report, however, is that PIS Consumer will entertain a court order and delete a post. They'll also potentially consider what we call a notarized letter. So you don't actually have to go to court and get an order declaring the content unlawful against the poster. If the poster is willing to basically create an affidavit or something similar saying that, yes, I posted this, yes, it was false at the time that I posted it, and, accepting those facts is true and getting it notarized, PIS Consumer will entertain those type of requests in terms of removal. Go back down to this next slide that talks about removing URLs from Google or other search indices. That's another option if you get a court order declaring content to be unlawful and say the content is located somewhere, in Panama, that you cannot, contact the website administrator and the poster can no longer get at it and delete it himself or herself. You can go to Google and submit a request there and request that Google remove the URL that contains the unlawful content, and remove it from its search index. That way, while the content still is out there, if you went to www.websitename.com/posting567, it's still there. But if it's no longer coming up on the Google search results, then Google has either de-indexed it or blocked it from its crawlers being able to pull it out. For most clients, that's obviously a good option. I get a lot of questions about Bing, which is also Yahoo. Yahoo uses Microsoft Bing search index. I've had mixed results, quite honestly, with getting things removed from the Bing search index. They've changed their policies several times over the past 5 years, and in my experience, it's kind of who you get a hold of there. Google is much more straightforward with what their policy has been and how they treat this type of thing. On that same vein, talk about actually pursuing a lawsuit here. Obviously, this is when you have a situation where there's content online that is sufficient to support a claim for defamation or breach of contract or otherwise. Again, some tidbits to remember in terms of actually filing the lawsuit. Go after the person who's actually posting, not the website. And then you get into all of the legal analysis that I won't get too much into, but things to consider and things to remember. First and foremost, jurisdiction. It's important to keep in mind, particularly when you're dealing with an anonymous poster. If you don't know where the person lives, obviously that's hard to determine where you have jurisdiction over him or her. You can potentially go where your client is or the plaintiff is and where the company is located, assuming that the harm is being felt there. This is where you want to get into looking at this particular state's long-arm statutes and whether any case law has been developed on a long-arm statute pertaining to Internet activity. Honestly, every state is different. Every state's long-arm statute is drafted differently, and a handful of states have analyzed the issue in terms of the long-arm statute, particularly in dealing with Internet defamation or like issues, and whether, someone in Alaska posting about me in Ohio and directing that activity to Ohio, arguably, whether the long-arm statute applies, even if that person has never set foot in Ohio. So you want to do that analysis before you even decide where to file your lawsuit. Along those lines, too, statute of limitations is important, particularly for defamation. The statute of limitations is very short, 1 to 2 years in most states, only 6 months in Tennessee, and 3 years in a handful of other states, but very few. So, that's something that I see all the time that people bring up, I tried to push it down for a little while, and it wouldn't go away. So now I'm calling you, and it's totally factually false, and I really think I have a good claim for defamation. Well, if it was 5 years ago, you may have had a good claim for defamation, but having a viable claim now gets much trickier, right? This is something else that's really state-specific in terms of whether a state has analyzed content online and what we call the single publication rule. Can you make a good argument that the statute of limitations is told until it becomes an issue for the company or person online, or every time someone accesses it, is the statute re-triggered, or is it really just a single publication, and if it was posted in 2010, that's the end-all, be-all date. Those are things that are really important to remember. Damages, obviously, is hard to prove in these cases. I get clients all the time that say, well, I think it's really hurting my business, but I wouldn't really know. How do I know who's seen it? And, of course, it's a good question, right? And that question has really been the basis for a number of the kind of very large jury verdicts we've seen in these type of cases, is that in my view, you get juries that are sitting there thinking, oh, my gosh, you posted something factually false and damaging about this company online, and that's horrible because we all look for good companies online, and we trust that, and who knows how many people saw it, and so, yes, $1 million kind of thing. So that's something to keep in mind in terms of, can you track the business, and how many leads were we getting from the Internet before this, and how many are we now? Website traffic and that kind of thing. Important to note, is defamation law in general does permit, most states have a claim for defamation per se, which is basically certain types of content is per se defamatory, right? You don't actually have to show damages to reputation or business. If someone posts something factually false about me in my, say, business or profession, that gives me basically that element of the defamation claim, the damage. Now, that may mean that you get basically nominal damages, say $1, but you could, of course, try to get some sort of injunction or judgment on that basis. In talking about defamation and other lawsuits, important to keep in mind, of course, is what we call anti-SLAPP statutes. SLAPP stands for a strategic lawsuit against public participation. My easy example of a SLAPP suit is the situation where a normal person is protesting, the big corporation's demolition of a historic building or something, exercising his or her, First Amendment right and being heard, and, I don't think this should happen. And what does the company do? Well, they come up with some kind of flimsy legal claim and serve the person with the lawsuit. And, of course, what happens then? Well, normal protester person doesn't have the money or resources to defend against said lawsuit, so what do they do? They stop protesting, they walk away. And a number of states have passed this type of legislation that basically is a procedural mechanism that in that situation, the person, the defendant, has a recourse in terms of filing usually a special motion to dismiss that usually stops discovery and gets into whether this person actually has a good legal claim or not. Almost every anti-SLAPP statute permits recovery of attorney's fees against the plaintiff should you lose. So, obviously we never recommend filing frivolous lawsuits in general. You want to have a good faith basis for any type of claim that you bring, but certain states have more liberal anti-SLAPP statutes than others, and so it can be a procedural hurdle in certain states that, people and attorneys will file this, and you get into this, and it can be costly and expensive. So it's important to keep in mind. I have a couple of miscellaneous things to talk about. I see a couple of questions, and some of those I am going to get to here shortly. So hopefully that'll answer the questions that you all have regarding some of these issues. Briefly about, I get a lot of questions about removing photos. Obviously, most social media applications have reporting devices. If a photo of a client gets posted on there, you can report the photograph and say why you don't think it should be on there. This slide kind of talks about where to go. Usually it's pretty self-explanatory. On that same vein, obviously, sure most people are familiar with the DMCA. Obviously, whoever took a photograph owns copyright to that photograph. So to the extent that, it's a photograph that I took of myself, we get that, unfortunately, as you can imagine, a fair amount now that, I sent this to a boyfriend, and then we broke up, and now he's posting about it online. Well, if it's your photo that you took of yourself, or a selfie, right, we've all read about the monkey selfie scandal and PETA filing a lawsuit on his behalf that he owned the copyright to his own photo. That if you own the copyright, obviously you can enforce your copyright and request a website take it down. Something else to keep in mind is even if you didn't take the copyright, even if your client didn't take the photo, to the extent that someone else took the photo, you can either represent that person for purposes of the DMCA or get that person to assign or transfer the rights to your client so that he or she can go after the submit a DMCA request and get the photo removed. Of course, not to get too far down in the weeds about fair use and copyright, but that's always something to keep in mind, that fair use is a true aspect of the law, so you want to make sure that there's not some other legal basis for why this person has the photo. Next thing I'll touch on briefly, I get a lot of questions about this in terms of damaging content about a client from a news source. The situation we usually see this in is, potentially someone gets arrested for something, charges are never filed or charges are dropped, and then, life goes on, and, 20 years ago this would be a complete non-issue, but in today's day and age, 4 years later, it's still coming up, particularly if the person has an unusual name and a newspaper reported on it and the article's still there. And, when you Google his or her name, this is the third thing that comes up, and, it was a complete non-issue and several years ago. Honestly, in these type of situations, you very rarely have a claim against a news outlet, right? Almost always it's, arguably true, and of course in defamation law, you're going to have to prove a higher standard of fault to actually have a claim against a newspaper or a news channel. So, very, very rarely are you going to have a viable claim that you can actually go after a news outlet for the content. What you can do, and what we've had some success in, just depending on the particular news organization, is to, reach out again, as we talked about even with the websites, and reach out with a request, asking if they'd entertain, to talk to you as the attorney or the representative about this and your client. And I've had a fair amount of success, talking to news stations about, okay, I understand that you ran this story and this was news, back in 2008, but it's not really news anymore, is it? And as you can imagine, this isn't the same as it used to be. This is really hurting this person's online presence. and would you consider basically taking the story down as it's, no longer relevant, X amount of years later. Another option is a robots exclusion, which is basically, without getting too technical, and it's not something I get too much into because I'm not super technical either, but basically the news organization or website can change the software that backs up the page so that web search engines like Google are not pulling up the page. I think there's a next thing we'll kind of talk about here. This is a good segue into court decisions. We've seen that a couple of times that obviously something comes up in an opinion, potentially there was litigation and, so-and-so alleged X, Y, and Z, and maybe even later on, the opinion's actually favorable to our client. But because court decisions are obviously public documents and they're getting posted online, someone's a search for someone's name on Google can pull up some of this content. It looks really bad. So we've had some success in going to those websites and asking that they use the robots exclusion device to, it's still up on the website. People can still go there and get it, but it's no longer coming up and looking bad for our client. Let me just skip ahead quickly. Unauthorized sales. I'll talk just for a couple minutes about identifying anonymous people online and kind of how that works. First thing you can do is, we've had clients have success outside of us, is using a cyber investigator. People can go to these companies. It can be an easy and efficient way of trying to figure out who the person is. They can do some searching online and try to match up, they use this username here and this username there, and, therefore, we're pretty sure it's this person. That's, of course, kind of the easiest case scenario. Other times, the investigator will actually, be more of a detective or a private eye and, create some accounts and try to obtain a IP address and that kind of thing. For a number of clients, that can be a good approach, or a number of businesses. We steer clear of that most of the time, caveat, just because sometimes the investigators use basically pretexting, right? They purport to be someone they're not, and of course, as attorneys, that's completely against ethical rules, and it's not something you'd ever do, right? That's the first thing you say when you're representing someone is that I'm an attorney, I represent so-and-so. So to the extent that your client wants to use a cyber investigator, there are certainly good reasons to do that, but be very cautious of that in terms of when they're doing that and at your behest. It's important to remember. Short of that is, of course, issuing a subpoena. As we talked about, a lawsuit, assuming that there's content online that is actionable, whether it be false, defamatory, or support some other claim, you would basically file a lawsuit. Most of the time, without getting too far into the weeds, you'd file the lawsuit as the plaintiff against a John Doe. The defendant is, an anonymous person. You name him or her as John Doe and lay out your legal claims. And then you can serve a third-party subpoena, basically on the website asking for any identifying information the website may have regarding that poster. This, of course, can be name, address, email, and what we call an IP address, an Internet Protocol address that was used to post the content. Very rarely do we get a name and an address, right? Most people that are posting this kind of stuff, particularly, again, if it's actually false and they're just doing it to attack or harm a business, most of them are not using their, real name. We get Big Bird at 123 Sesame Street. So, very rarely are you going to get that type of information. What you can get often is the IP address. Once you have an IP address, you can then go to the Internet Service Provider and sorry, I'll go back just quickly. You can go to the Internet Service Provider, and that's, who provides your Internet, whether it be Verizon, AT&T, a cable company like Comcast or Time Warner, and you issue a subpoena to that ISP, as we call it, and request information their customer information pertaining to that IP address at the date and time that the content was posted. That's really important because most IP addresses, particularly to residential accounts, your internet at home, are dynamic, which means they change. So going to Verizon and saying, hey, give me your customer information for IP address 222227. They're going to look at you and say, don't know what you're talking about, because that can change at any time. You have to say, I want your subscriber information for IP address 22227 on March 23rd, 2016 at 9:53 a.m., and that kind of thing. Then they can come back and produce the information. That's our best case scenario is when if someone has done it, from his or her house or, and you can basically track down that obviously where that posting came from. If it's not a dynamic, which means it changes, it can be to a business. Obviously, sometimes people are, for whatever reason, whether they're smart about posting this stuff or they just got lucky and they go to Starbucks or a public library. Of course, that can be a lot harder because how are you going to determine who was at the library at that date and time and posted it? Important to remember when you're issuing your subpoena, obviously, you file your lawsuit and have your legal claims. Almost all websites and Internet service providers will provide notice to the poster that they have received a subpoena for personally identifying information relating to the content, relating to his or her identity. The website will then give the poster a certain amount of time to respond, and basically what the process would be is if he or she thinks that you shouldn't get his or her identity because they think that the speech is protected and therefore, their identity should remain anonymous, they'll file a motion to quash. This slide here talks a little bit about the legal standard. Of course, not every state has determined the proper legal standard for this, but most states follow a pretty straightforward test similar to New Jersey's dendrite, which is laid out here. I like to think of it as a kind of high motion to dismiss standard in terms of what you would have to overcome in order to obtain the information. So that's important to remember. We'll just, here's some subpoena tips. We can talk a little bit if people have questions about federal versus state. You get into, obviously it can get tricky depending on where your lawsuit is and where the website is located. You get into foreign jurisdiction. Most states have enacted what is called the Uniform Interstate Deposition Discovery Act. So that's made it in the past 10 years a lot easier for me to file a lawsuit in Ohio and then go to California and serve a subpoena on Google. But I always tell people, kind of start with your state's rules and look at the foreign states' rules, and that'll start you off. Quickly, John Doe subpoenas in 3 steps. We just went through all this, but this kind of lays it out. You subpoena your third-party website for personally identifying information. If you only obtain an IP address, you need to look up the Internet Service Provider. This is publicly available information. You can go on to Whois and look up the IP, and they will tell you. This gives an example that it's that IP address is registered to Time Warner Cable. And then you would go to Time Warner Cable and request the account holder information based on the IP address. A couple other things just to remember. Give me just a second. Publications. I'll talk just briefly. This comes up sometimes in our cases. in dealing with online posters and online content and people who have posted online anonymously and then say, oh, it wasn't me. We have been successful in a number of matters in doing forensic exams of defendants' computers and devices. It can be very expensive, obviously, and very unwieldy, but it's a really good solution in those cases that you're dealing with that, you serve a bunch of discovery and try to tie the person to this attack or all this content and stuff has been deleted. You can actually go on, you can actually pull the devices and get a forensic image made and take it to a forensic examiner who can go look at all the content, find information even that's been deleted but is still in what they call the slack space of the computer. Of course, this can also be helpful in terms of even if everything's gone, if it was all deleted on a certain day or time after initiating the lawsuit, it brings up obviously spoliation concerns. We usually do this through obviously discovery requests, and oftentimes you're going to have to actually file a motion with the judge to request you do a forensic exam. But it's a good tool in those particular cases that gets important.